It's June 25th, and this is the evening edition of Mike and Bike. So in this episode, I think I'm going to start off by talking about the recent U.S. Supreme Court decision. Just today, it was announced about the company Aereo that sells subscriptions for television, for broadcast TV over the internet. They have these banks of mini antennas that pick up broadcast TV signals in various cities and then sell it to consumers in those cities so they can subscribe to get access to all the TV stations in the US cities where they live that are broadcast channels. And this was contested by the television networks. They felt this was stealing, or this steals their content, violates copyright, and that they should be paid for retransmission of their stations. Of course, one of the biggest sources of revenue that television networks have, these broadcast networks have, is the rebroadcast rights that they receive from cable companies. So companies like Comcast and Time Warner, they pay substantial sums to the TV networks for the right to carry their signals to their cable customers. And Aereo had the potential to disrupt this whole business model by allowing people to pay for getting access to or digital streams to television networks without having to pay for a cable fee and a very low monthly fee to get access to those channels. And the U.S. Supreme Court has basically said that this Aereo is violating the copyright of these TV networks, and that they should have to pay retransmission fees, just like cable companies. And this pretty much brings to an end the business model that Aereo is trying to establish. I thought they had a pretty good argument by saying that each consumer would have their own antenna. Because they have these tens of thousands of mini antennas at each Aereo center. And so each consumer is paying to basically lease one antenna, which then they pick up is rebroadcast to them over the internet, the signal from that antenna. And I thought that was a legitimate argument. The Supreme Court justices felt that it was basically a loophole in the law, and that the technical way in which Aereo worked was irrelevant from how the service they were offering, which I guess is kind of if it talks like a duck and quacks like a duck, then it must be a duck, regardless of what's going on underneath. So they basically said, hey, you're providing a cable service by any other name, and you're not paying these broadcast networks for their signals, so you ought to do it. And your obfuscation by using mini antennas for each individual customer is irrelevant. I can see that argument. I can see why they ruled the way they did. Personally, I wish they'd ruled the other way. But there is a logic to what they did. The thing that does bug me, though, which was out of the Supreme Court's purview in this ruling, and I think is an injustice, is that the broadcast networks are basically getting free assets from the government, and they're not really delivering. Specifically, the broadcast networks are getting bandwidth. They are given bandwidth for in frequencies for broadcast signals, for broadcast television. Yet it's really not something that's that usable by anybody, the product that they are delivering. And through broadcast, the fact that so many people receive their these broadcast channels over cable networks is ample evidence of that. The reality is that the broadcast quality, the quality of the broadcast signals these stations generate, is terrible. I can't pick up a single TV station in my home, and I live in a city and region of significant size. So all I can get is some Spanish religious channel. I haven't tried hooking up some massive antenna, but this has been my experience pretty much everywhere I've lived, that the broadcast signals were very poor. So here we have the government giving a free good, giving an asset to these broadcast networks for free, at which these broadcast networks aren't giving much back in return, and instead are demanding fees from anyone who wants to rebroadcast their signal or carry their signals or their channels, programming. I also don't really understand what the complaint is, what their beef with things like Aereo are. I mean, they may have a valid legal argument, but I don't see how Aereo really hurts these channels. Well, I guess it does hurt them in the sense that people who subscribe to Aereo wouldn't be subscribing to cable and thereby paying money that the TV stations would get a portion of. Okay, so in that sense, there's some harm. But it doesn't hurt their advertising revenue, because Aereo was rebroadcasting everything, the advertisements and the whole and everything. So anyone subscribing to Aereo would still be seeing all the ads that they would normally be getting. But it's all kind of irrelevant anyway. I think we're fast moving to a model where people are just going to get their content over the internet. the cable subscribership is actually dropping. We're seeing more and more people just cutting the cord or cutting the cable and going with internet connections. With streaming services like Amazon offering video and Netflix and iTunes, there's increasingly little reason to have your own or to have cable service. As I've mentioned in previous episodes, my family, our household cut the cable, I don't know, 4 or 5 years ago, and we don't regret it at all. There's the odd time where we wish we could watch a live event. But those times are so rare that it's not really compelling enough to get a subscription to the cable TV. For example, we wanted to watch the Super Bowl recently because the Seattle Seahawks were contestants in it, which is our home team. So, but as it happens, the Super Bowl was broadcast live over the internet. That one football game was made available for free over the internet. So we just hooked up an HDMI cable to one of our laptops and watched the football game on our TV at home. Very slick. So I suppose big sports fans or people really into sports, that's the one area I can see where live feed can be important. And for those people, then you can go with a cable TV or something. For everyone else, though, it's kind of a waste of money. But back to my complaint about the broadcast networks getting free spectrum from the government. I think Congress should revisit whether the broadcast networks should continue getting free spectrum anymore. If they're not delivering anything of value with that spectrum that is accessible by only a small number of Americans, then it's a waste of public resources that's being given away. if the broadcast networks want people to pay for their content and for receiving their signals, then great, they should be able to do that. But let's not let them take advantage of free radio spectrum for the privilege, if that's what they want to do. I also noticed that the Supreme Court ruled today on privacy rights of cell phones and declared that the police cannot search a cell phone for the content of a cell phone when they arrest someone unless they have a search warrant. I don't know what I think about that, honestly. I have to do I have to consider that more about whether the police should or shouldn't have that right. But I find it particularly interesting in lieu of my previous episode, MicAndBike episode, where I pondered the existence of a world with no secrecy for privacy. So here we have a situation with the judicial system trying to enforce privacy rights and keep some things private to some degree, at any rate. A lot of questions. I don't know enough about this particular case with cell phones. I mean, what has the law been previously in the case where somebody has, say, a briefcase on them when they are arrested? Have the police had the right to rummage through their briefcase, or would they need a search warrant for that? I don't know. I would think that whatever the standard applied to a briefcase somebody was carrying, or pack-sack, the same thing would apply to a cell phone that they might have with them. Even though a cell phone might be small enough to be in your pocket, whereas a briefcase would be something you have to carry with you. I would just think the same standard ought to apply. I think today I'm going to be jumping around topics a bit. I didn't have a specific topic to focus the entire ride on. I was reading more articles about the Mormon Church and its history of excommunications, some of which I found pretty interesting. So I should make it extremely clear, I don't want to pick on the Mormon Church, because I think they're pretty good as far as churches go, and there's a lot that I could pick on with other churches if I wanted to. So with that context, It's interesting to read about the history of people who've been excommunicated in the Mormon Church, and certainly for apostasy, which is basically blasphemy. And there was a group of 6 people who were excommunicated in 1993. Some historians and feminist writers at the time. And there's quite a long history, actually, not of a lot of these kinds of excommunications, but some. But it's also interesting to see who wasn't excommunicated. There was this really fascinating article I read by a Mormon mentioned there was some guy in the 50s who was quite a heretic, who said lots of things publicly that were contrary to church canon. And at one point they actually began excommunication proceedings and investigation into him, but the prophet of the church at the time, David O. McKay, let it be known that if they were going to have an excommunication proceeding against this man, that he was going to be the first witness at the proceeding. And pretty much unstated, but that he would be giving a defense of this person. So that they ended the investigation right then and there. Now this guy continued to be, he continued his heretical comments for I guess the rest of his life, and he never lost his membership in the church. I guess it helped that he was related somehow to Mr. McKay. But I also think that in light of the other people who have been excommunicated, one difference is this guy didn't have much of a following. And I think from looking at the history of Mormon excommunications, a big factor is the kind of following you have. And if you really are persuading others and shows that you're gaining some traction in your heresy amongst other members, that pretty much seals your fate. You can go on railing whatever manage of poppycock you want, and the Mormon Church seems to not really care so long as you're just viewed as a loner. So you're really in trouble if anybody else thinks you're talking sense. I also found it a little disturbing to read about some of the goings on and policies of David O. McKay, or not David O. McKay, of Boyd K. Packard, who was in charge of the church education system for a long time and is, I think, one of the general authorities of the church. Today, I'm not sure if he's an apostle. He could be. He made some comments in the, I don't remember, late 70s or 80s, maybe 80s, likely 80s, I think, like 89, something like that, maybe, to the effect, his comments were to the effect that history is that the truth, historical truth, is not helpful if it causes confusion and could jeopardize the faith of members. And the very real inference was that people just shouldn't be uncovering some facts about the church or talking about them, of some of the church history. So some historians, hello. So some church members who were historians that spent their time documenting some of the doctrinal disagreements in the church over the years, and those disputes ran afoul of Mr. Packard. And in Packard's view, what good does rehashing these old arguments do? Why should we dredge that up so that modern members can see there were disagreements on key points of doctrine 100 years ago or 40 years ago? Is all we need to know is that they were resolved. And this is what the doctrine is today. I don't know, that bothers me. For one, I think it's kind of condescending to say that that some members' faith is so tenuous that it would be destroyed if they knew of disagreements that had occurred in the church, for example. So I think that's condescending. I also think it doesn't give enough credence to how knowledge of the past can help build one's faith. If you understand your history, it can give you, in many cases, a richer sense of your religion and so on. For example, it is clear now from the delvings of some of these historians that were dubbed heretics, that delved into the history of polygamy in the Mormon Church, that the ending of polygamy was not a cut and dry thing when Wilford Woodruff made his pronouncement, I think in the 1890s or 1890, I think, something like that. His proclamation was somewhat ambiguous, or his proclamation prohibiting polygamy was ambiguous, and it was not made as a part of as official revelation. So the way in which that proclamation was made, it wasn't at all clear that this is what the Lord is asking. He was giving this statement that he advised members of the church not to do, not to participate in polygamy. And indeed, many leaders of the church continued practicing polygamy for some time. High leaders in the church, in fact. And it wasn't for some 20 or 30 years that the Mormon church really came down heavy on polygamy in the church, and particularly amongst its leadership. Well, that ends this episode of Mike and Bike. Caught up on me this time. I'll talk to you all later.